All right. Welcome, everyone. My name is Karen Faradin. I am the co-founder of the Better Path Coalition. And so we are thrilled to be bringing you this uh, great webinar today. The Better Path Coalition is kicking off its new series, Informing the Resistance, with two webinars this week that we are co-hosting with Green Amendments for the Generations. Big thanks to Maya Van Rossum, founder of Green Amendments for the Generations, for arranging for Mark Freed to speak today on curative amendments. We'll introduce him in a moment, but I have a few announcements to share first. First, this Thursday at 7, Maya will be our speaker on the topic of Article 1, Section 27, Pennsylvania's Green Amendment, and how to use it properly. If you're interested in joining the discussion on data centers in Pennsylvania, we have a Facebook group, Pennsylvania Data Center Resistance, that has now topped 40,000 members. It's actually 40.5 thousand members as of today. I will share the links to those in the email that I'll send to you afterwards with the link to the recording of today's webinar. But finally, you've heard me say it when you were in the waiting for the webinar to start, but please remain on mute during the presentation. And again, put your questions into the chat for the Q&A that will follow. And so with that, Mark Freed, a partner at Curtin and Heefner, is an experienced municipal and environmental attorney who well understands the protections and benefits curative amendments can provide to a community. For more than 25 years, Mark has represented clients in the areas of municipal law, environmental law, and litigation. He serves as solicitor to a number of area municipalities. He also served as a member of the Board of Supervisors of Tredyffrin Township in Chester County. Mark was named a Pennsylvania super lawyer and has served as a member of the Pennsylvania Pipeline Infrastructure Task Force Local Government Workgroup, as a member of the Pennsylvania Environmental Justice Advisory Board, on the executive board of the Chester County Association of Township Officials, and on the board of advisors to the Upper Main Line YMCA, on the board of directors of Global Water Alliance, pardon me, a nonprofit dedicated to increasing global awareness to safe drinking water, sanitation, and hygiene services, and as an adjunct professor at the St. Joseph's University Graduate Institute for Public Safety and Environmental Protection. Prior to joining Curtin and Heefner, Mark served 8 years as assistant counsel with the Pennsylvania Department of Environmental Protection. At DEP, he was lead counsel to the Southeast Regional Waste Management and Water Supply Management programs. He also counseled DEP's water quality, storage tanks, and land recycling programs. He also served 2 years as a criminal prosecutor in the Pennsylvania Attorney General's Environmental Crimes Section, where he prosecuted cases involving water pollution, hazardous water, and storage tanks. Mark has argued and tried numerous cases in state and federal courts, including the United States Court of Appeals for the Third Circuit and the Pennsylvania Supreme Court. So with that, thank you so much for joining us today, Mark. Please take it away.
So thank you for having me. I should say that some of those affiliations are past affiliations. I'm more maybe of a has-been now. I am still practicing law. I am no longer on the Board of Supervisors, although I am a solicitor to a number of municipalities, and we deal obviously with issues related to the municipalities planning code and in general and curative amendments in particular. So I appreciate the opportunity to talk about these issues. So we're here today to talk about curative amendments, particularly municipal curative amendments. But before we get into that, I wanted to give a brief background in what curative amendments are and the different types of curative amendments you can have. So curative amendments are a action that can be brought under the municipalities planning code, which is the Pennsylvania law that generally regulates land use activities by municipalities. There are two types of curative amendments. I'll start with the one that we're not going to be really focusing on, which is landowner curative amendments, which gives a landowner who feels that they've been negatively impacted by a zoning ordinance on property that they have. It gives them an opportunity to seek a change to a municipal ordinance. Um, Related to the landowner curative amendment is also there's provisions on substantive validity challenges. They're sort of interrelated and overlapping. They they allow, and the reason that there's a distinction there is some actions can be brought before the governing body, which would be a board of supervisors or a borough council, and other actions, particularly substantive validity challenges, can be brought in front of the zoning hearing board as well. So there's different venues where someone can go to challenge the substance of a ordinance. There's also something known as a procedural challenge, which we're not really getting into there, but there are ways of challenging the procedure by which an ordinance was enacted. Usually that has to be pretty timely with the enactment of the ordinance. It's not something that you can do much later, like you might be able to do with a substantive challenge. Um, so when we're dealing with landowner curative amendments, and this is only important in the sense of what a municipal curative amendment is not. So it's helpful to know what a landowner curative amendment does and why we even have municipal curative amendments. If someone brings a landowner curative amendment and they're successful, there's a whole number of benefits that they may be able to obtain. The developer will have 2 years from the date of the approval to file an application for a preliminary or tentative approval. And during that 2 year period, there can't be any change or amendment to the zoning, subdivision, or other governing ordinance that would adversely affect the rights of the applicant. The other issue, and this is a potentially very big issue depending on the issues that are in front of the court if this goes up on appeal, is that a court may order the described development or use approved as to the elements, as to all the elements, as to some of the elements, or take other similar actions. So there's the chance and the risk that if someone brings a substantive validity challenge or a landowner curative amendment, that potentially, if they prevail, a court can grant the proposal that they wanted to make. And that's a pretty powerful tool for a developer. Um, so then let's talk about the other curative amendment, which is really the main thing we're here to talk about today, which is the municipal curative amendment. And this is something when instead of the landowner alleging that the ordinance is invalid, the municipality determines itself that its zoning ordinance or a portion of the ordinance is substantively invalid. Um, and there's a process that if the municipality wants to do that, there's a process that they would go through in order to declare their ordinance invalid and to take action. So first, the municipality would declare its ordinance substantively invalid. That could be done by resolution or motion. And then they would begin to prepare and consider a curative amendment within 30 days of that declaration. Once they've enacted that declaration, then there's 180 days to enact the curative amendment. Um, because it's such it's sort of an out of the usual process that a municipality can take. What the municipality's planning code says is that a municipality can only use this once every 3 years. So if you use it, and it's one of the reasons that you have to be careful not to overuse it, because if you use it and then something comes along that really you find to be invalid, you can't do anything. Now, even outside of the curative amendment process, a municipality can always move to change its ordinance. What it doesn't do, and we'll talk about the protections it gives and the protections it doesn't give once a municipality declares that it wants to do a curative amendment. But if you just do a normal change, you don't get that protection, but you're not prohibited from changing your ordinance. Municipalities are changing ordinances all the time. A lot of my municipalities consider the ordinances to be living documents, and when they see something that needs to be tweaked or fixed or modified, they do that. So, and I'm going to break my rule of, even though these slides tend to be pretty dense, this next slide is particularly dense, which is against the rule that I have for not having too dense, but I wanted to, because this is sort of the key issue. And I know that one of the issues and really what motivated, I think, the request for me to speak today is this question about whether a municipal curative amendment acts as a moratorium on land development while the ordinance is being developed. And I will give you a spoiler. It does not, and we'll discuss how and why and what it does do. So the real core of what the municipal core of amendment does or doesn't do is contained in this section of the municipalities planning code, which is 609.2 subsection 3. And it says, upon the initiation of the procedures, the governing body shall not be required to entertain or consider a landowner's curative amendment, which we talked about at the beginning, um, and no rights to cure pursuant to the provisions of 609 or 916, which are the sections that are either cover landowner curative amendments or landowner substantive validity challenges. Essentially, they're precluded from bringing those actions during that time. And we'll talk about why well, we've already talked about why that's important. Because you saw if someone can bring a substantive validity challenge, the potential is that if they prevail and prove to the zoning hearing board, the governing body, or particularly to a court on appeal, that the substantive, that the ordinance is invalid, they potentially can get the court to give site-specific relief that would grant the development and potentially take it out of the hands of the municipality. I, we are involved in a number of cases related to that. We think there's some limits on what a court can or should do in those circumstances, but that's certainly, it's going to depend on the court. It's going to depend on the judge, what issues that you're going to have, and you may be left if you disagree with the result of having to bring an appeal. So it's pretty powerful, as we said, for developers. And the one thing, and the primary thing that a municipal curative amendment does is, if the municipality acts first to declare that its ordinance is invalid, it cuts off the ability of the developer to come in and potentially get that special relief that they'd be seeking if they win. As I mentioned, and as you saw in the last slide, there was nothing about the fact that the curative amendment acts as a moratorium on the ability of the municipality to consider or act on existing or new applications. There are other rules that deal with that we'll talk about. And when you have a municipal curative amendment, you're still subject to those other rules. This doesn't create a special rule that would somehow act as a moratorium. So here's essentially what the municipality's planning code says about what we call, it's sometimes commonly known as grandfathering. So prior to the municipality's planning code, there was a doctrine known as the pending ordinance doctrine. And it still survives to some extent outside of the land development context. If it's truly not related to a land development, I'm a person, just to give one example, I'm a person building a house, an individual house. It's not a land development. I need some approvals, some building permits, other things of that nature. The pending ordinance doctrine can apply. And in that situation, under the pending ordinance doctrine, once a municipality advertises that it's going to change its ordinance, that can protect the municipality from an application coming in that would be contrary to that ordinance change. What the courts have said, however, that in the context of land development, in particular, and some other circumstances, but particularly land development. Um, the municipalities planning code trumps that common law provision. And just so folks know, common law is essentially judge-made law. If you go back in time to the beginning of the court system, there was a lot of judge-made law. It's law created by the judges over time based on precedent and other things. But if a statute is passed by Congress, by the state General Assembly, and other, governing bodies, that can trump the common law. The judge then has to abide by what the statute says. And in this case, there's statutes, and what the municipalities planning code says is from the time and application for approval of, and they call it a plat. It's the same thing as a land development application, is filed, the applicant shall be entitled to a decision in accordance with the provisions of the governing ordinances or plan as they stood at the time of application. And that applies, and there's another related provision that deals when an application for a special exception or conditional use is filed, the same thing applies. And a conditional use or special exception is a type of zoning relief that you can get under the municipalities planning code. So we don't need to get into the details of that, but there's a couple of different situations. But the reason I brought that up in section 917 is the main case on the issue deals with section 917, although we believe it would be equally applicable to the under 508 as well, which deals with land development. And so what this all really means is that once an application comes in, and I'm going to use the land development example because that is mainly, I think, what we're talking about and what people are concerned about. When a land development application comes in, that the developer gets the benefit of the ordinance until such time as the ordinance is changed. And if you're going through a curative amendment process, that means that, until the end of that 180 days or however long it takes the municipality to change its ordinance, an application can come in. And this is obviously one of the concerns for a municipality, whether they're going through a curative amendment process or they're just going through a regular ordinance change. Once it's advertised, potentially somebody can come in with a race to the courthouse steps situation and get their application in before the ordinance is changed. And under the municipalities planning code, that's allowed. The protections of the pending ordinance doctrine in those situations are not going to apply. So while the MPC requires the public notice, the advertisements, that someone can then, during that period between the advertisement and the enactment, come in with an application and be protected under the old ordinance. So why do I say this, that the municipal curative amendment is not a moratorium? So there's a couple cases, but the main case on this topic is a case called Lehigh Asphalt, which is listed here. And I pulled out one of the most, what I think is the most applicable quote, which is the township's implementation of a curative amendment procedure of the MPC did not operate as a rescission of the existing provision, which prevented Lehigh from relying on the existing provision as it is permitted to do so under 917. And the reason they're citing 917 here is because this was a situation that dealt with a special exception, although as we saw from the prior slide, there's a similar provision that deals with land development. So essentially what the court's saying is that general rule we looked at, where you can be grandfathered until the ordinance change, is going to apply even if you're in a curative amendment situation. So then the question people are going to ask is then, what the heck does a curative amendment get the municipality? And we talked a little bit about this, but then, Lehigh Asphalt also goes through that and explaining what it is you do get. And they described it as you get to avoid the harsh remedy sometimes imposed when a landowner prevails in a validity challenge or a curative amendment application, i.e., the forced acceptance of a land use or development that the municipality considers undesirable or at odds with its comprehensive plan. So that's essentially why a municipality will invoke the municipal curative amendment. It's not to act as a moratorium, although sometimes that happens. And some of the cases that have dealt with this issue are situations where a municipality, whether it's the zoning hearing board or the governing body, says, okay, we've done a curative amendment, we started the process, we don't have to decide this. And then you'll get a situation where someone will bring one circumstance is someone will bring a mandamus action. That's a type of action where someone can force a government to take an action that they're supposed to take. And the defense that has been raised is by the municipality is, well, we don't have to do it now. We've started the curative amendment process, and the courts have said, no, that doesn't matter. They've submitted something. You have an obligation to act, and frankly, under the municipality's planning code, in a number of situations, if the municipality does not act, it's a deemed approval. And basically the developer gets to do what it is that they applied for, and it's deemed approved even without conditions. So that's basically the content that I have today. Sort of getting at, I know it's short and but really getting at this question of does the municipal curative amendment act as a moratorium? Wasn't really the intent of this to take a position for or against any particular industrial development, but really to help people understand the process.
Thanks so much. We have a couple questions, and I wanted to ask a clarifying question just up top, because at the beginning, you were saying that you can't do another curative amendment process for 36 months, was it?
Correct. That's right. 3 years.
But you did say that municipalities change their ordinances all the time. So as long as you're not calling it, you're not going through the process, but you want to make another kind of change,
So
are you
what,
prohibited?
right, what you're not prevented from doing is changing your ordinance. What you don't get when you do that, if it's not in the curative amendment process, and I'm going to read the court. What the court's saying you don't get would be to avoid the harsh remedy imposed if a landowner prevails in a validity challenge. So a municipality can say, we're not going to go through the curative amendment process. We're just going to change our ordinance. Well, during that period and until the ordinance is changed, someone could come in with a curative amendment, a landowner curative amendment or substantive validity challenge. And you can't cut that off just by changing your ordinance until the ordinance is actually changed. Just because you're in the process of changing it, someone can still come in and it becomes a little bit of a strategy. They could come in and essentially say, we've brought this, and if we win, we're going to ask the court to, or the zoning hearing board or whoever, to give us our development the way we want it, and we're not going to let you comment on it or do a bunch of other things. So you can change the ordinance, but you don't get that protection against the substantive validity challenge of the landowner curative amendment.
Okay, thank you. And so Jeff in the chat had asked, could you please give examples of the types of things that could be considered invalid and subject to challenge?
Um, yeah, I mean, there's any number. I mean, I think the one of the big ones that tends to come up is if there's a type of use that's considered a broad category of a use and it's not allowed, it's not provided for, or maybe even it's prohibited in a municipality. As a general rule, and it's a general rule, and you can get into all sorts of questions about what it means, but as a general rule, a municipality has to provide for all lawful land uses. Doesn't mean they have to provide for every aspect of every lawful land use. One of the examples I sometimes use, and that sometimes comes up, is you may need to allow for billboards. Do you necessarily need to allow for electronic billboards, right? So it depends how closely you slice it. But the best example I can think of is where someone claims that their use is not permitted under the ordinance, and therefore they're gonna bring a validity challenge and claim we want to put this wherever they want to put it. And that sometimes happens where people make that claim.
We got a question in the chat about whether or not you're willing to share today's slides. We are recording it. We'll share the recording, but is that something you're willing to let us?
Yeah. As I was going through it, I did see a typo, so maybe I'll fix that before I send it over. But sure, I don't have a problem with that.
Oh, that's great. Thank you so much. We don't have, oh, here's a new question. Sorry. Can, I'm trying to get past all the various things. They've really muddied up the screen here. Can neighboring landowners, local farmers, and residents use the landowner curative amendment somehow against the data center?
Um, that's an interesting question. And I'd have to look at the specific language. I usually see it in the context of the landowner who owns the property. And I think I'm going from my memory. I think that's the way it's written, that it's really geared towards the landowner who owns the property. But without going back and looking, I don't know 100% if it can be used by the third party who might be adjacent to it.
We have
I
another.
think though, what people can do is they can always, they can always ask or petition. It wouldn't be a formal petition potentially under the MPC, but you can always make the request, and then the municipality can choose to do it or not do it.
And we have another question. Is there a difference between a landowner curative amendment and a validity challenge?
So it's a great question. They're similar. There's a lot of overlap. A landowner curative amendment generally is in the context of bringing the action in front of the government governing body, in front of the Board of Supervisors, in front of Borough Council. It sometimes can be combined with a substantive validity challenge. Um, the but you can also have a substantive validity challenge in front of the zoning hearing board that would not involve a curative amendment. That's so it's essentially they're related, sometimes overlapping processes. Um, the easy way to distinguish them is one curative a landowner curative amendment always involves the governing body, whereas the substantive validity challenge can also involve the zoning hearing board. And it's really the landowner gets to choose which venue they want to go to.
We have another question. If a borough initiates an ordinance change, if a developer sends in a proposal after the change, oh, just hop away from me. After the change is initiated, no curative amendment applied for. In other words, the developer isn't grandfathered in under the old ordinance, correct? They're bound by the final ordinance change, correct?
Well, once the ordinance is actually changed, if the application comes in after the ordinance is changed, if the application comes in after the ordinance has been adopted and gone into effect, they're subject to the new ordinance.
So if the application comes in prior, does that mean the old ordinance stands? That's what.
In the context of, say, and I'm assuming we're talking about land development, a land development application, yes, the prior ordinance would be the one that applies to that development.
Now we have another question from Colby in Montour County. We made data centers built in an industrial zone land under conditional use process. If a data center developer feels we do not give them enough land or the ordinance is too restrictive, what legal avenue would you suspect they would pursue?
If the argument is that you've improperly limited the amount of commercial property you have in your municipality. Again, I think that's similar to the situation you see where they're saying you haven't provided for this use. I think they would be saying it's substantively invalid. It's not allowing me to do a use that should be permitted under the law. So you might be subject to a validity challenge. Whether it's valid or not, would depend on the specifics. It's very hard, to talk in hypotheticals, but I could see someone at least, in the right circumstances trying to bring that type of action.
I don't, oh, wait, here we have one more question that keeps coming. How can the public, and is the public involved in the curative amendment process once initiated? So is there a public
Yeah, it
comment?
goes through, it becomes, I mean, it goes through a hearing. If it's in front of the zoning hearing board, it's a zoning hearing proceeding. If it's in front of the governing body, it's going to be a proceeding, there's going to be hearings. Either way, there's going to be hearings and people can, participate in those.
What if there is an industrial region, but other developments are already in the area? Is there a specific amount that needs to be allowed?
So if you're talking about a particular use versus just generally, um, I, particular use, I don't know that it's an interesting question. I don't know that a municipality can say, for instance, we have enough warehouses, we're not going to allow any more warehouses. I think, if there's a district that allows, and I'm just using a warehouse as an example, there's a district that allows a warehouse, it's a permitted use, and someone comes in that meets all the requirements of that permitted use, I think they can put another warehouse in.
And
Oh, assuming they meet all the other requirements.
And this is another question about the curative amendments and their contents. Can they be about things like sound, light, emissions, pollutions, various kinds of nuisances?
I'm trying to think of the context. I mean, that may come up in the context of a curative amendment, but essentially a curative amendment is saying that there's something. Are they saying that there's something invalid? Like I'm not really sure I understand the question. I'm trying to think of how that might come up, where someone
Yeah.
would say, my ordinance is invalid because we have a lighting ordinance, or we don't have a lighting ordinance. I don't know. I don't know that I've seen that, but again, it's a question about whether there's something, as a broad brush, it's about whether there's something that makes the ordinance substantively invalid. If it's not valid, and again, normally in this context, it has to do with are the requirements, unlawfully restrictive? Either they don't allow the particular use, they don't provide enough, room for, let's say, industry. They don't have an industrial zone, or they have an industrial zone that's very, very, very small, and nothing can really go there. I mean, that would be the kind of situations I'd expect to see a validity challenge.
I don't know that this was her intention in asking, but the thing that occurs to me when I hear that question is, you just mentioned a situation where there's a small area, like I'm in a
Mm.
pretty well-developed municipality. If they were trying to shoehorn something in, they wouldn't be able to do it without causing, various problems for neighbors who would just never be far enough away. So would that pertain to things like setbacks? Is that something that would be, uh, something you could use the amendment for?
You mean you're saying if there's no setback, if for some reason they change it and they remove setbacks?
Yeah, I mean, I'm asking because this is such a new thing that, we haven't really had to deal with before. So it's posing brand new challenges we're still figuring
Yeah,
out.
I,
And
I will
so,
tell you
yeah,
my experience is that municipalities, whether they're and again, a lot of my municipalities are coming up with new ordinances to deal with all sorts of new, industrial uses. And generally, when they're being developed, they are going to include things like setbacks and other types of requirements like that. So it's hard. I think if someone wanted relief from that, I would expect that practically speaking, they'd probably have to go to the zoning hearing board for a variance. If it's in the Saldo, they'd have to get, ask for a waiver. And that's where you could raise the issue saying, they shouldn't get a variance or they shouldn't get a waiver. I think that's how
Mm-hmm.
probably come up.
And Colby, thanks you for your answer to his last question and ask now, if the developer wins that hypothetical validity challenge, does that mean they can pick the area to build and also ignore the conditional use process?
So that's the $64,000 question. So I think it really depends on what the challenge was, and what the court is that you're in front of and what the judge, says. If someone comes in, I would argue, and again, someone could argue differently, and I don't know that it's a settled question for some people because I have it as, at least in general, I have some of these issues. If someone argues, well, gee, we don't like this one ordinance. We don't like an ordinance because we think that, I don't know, your wetland ordinance it's unduly restrictive. It goes beyond, the way you define wetlands is so broad that no one can do anything, and you're preventing me from doing something that's just not reasonable, and they bring a challenge. You know, should in that circumstance where the land development hasn't gone through a land development review, should the judge say we're just going to approve the whole land development? I don't know. I would argue no. I think other people might argue yes. But if someone comes in with a land development application or something very broad and it's been vetted by the municipality, it's been commented, it's gone, and then it gets denied because they're saying, we looked at everything and we just don't think this meets our ordinance, and you believe that's because the ordinance is unfairly, restrictive, then I think, a judge could, you know, fairly say, okay, we're just going to approve this thing. But unfortunately, there's no bright line on when they're giving site-specific relief, um, on the extent of the site-specific relief that they're going to give. I think it's a very case-by-case determination. This is my
Uh,
experience anyway. Yeah.
the next question is about examples of arguments within a municipal curative amendment that carry weight. And he gives some examples of like violation of the Environmental Rights Amendment, too much intended water or energy use, habitat loss.
Yeah, I mean, again, I mean, another one that often comes up in the context of validity challenges, and again, I'm using validity challenge and curative amendment. This is more in the nature of landowner validity challenge and curative amendments. Sometimes you get spot zoning, which is sort of the opposite of excluding. It's actually allowing something, but maybe where it doesn't belong, and it looks like it's just being done for one lot. Um, but it's really it's kind of difficult to start going. There's any number of reasons that something can be substantively invalid. Um,
And Jeff asks, just to be clear, a landowner cannot file a curative amendment for properties that they do not own, but are adjacent and they'd like to own in the future, correct?
that's where I was saying I think that's right, but I'd have to go back and look at the exact language and see if it's ever been done. Again, from memory, I thought that's the way. Certainly, it's what you see most. Certainly what I generally see. I When I was looking, reviewing the statute just a little bit before the presentation, my recollection is that it deals with the landowner who believes that the ordinance is preventing, is somehow negatively, invalidly impacting them. But again, there might be situations where a third party, I haven't seen it, and I don't know. So I don't want to say for sure one way or the other, but generally, I would think it's generally going to be the person who owns the property that they want to develop that they can't develop.
And Jill asks, have you seen any challenges go to court? If so, who are the courts siding with?
It all depends on the facts. Yes, I've seen them go to court. I'm dealing with some. Um, and it really just depends. It all depends. I mean, a lot of it becomes whether or not, again, looking at the issue of is it overly restricted? Have you not permitted the use, sufficient amount of the use, or the type of use? And it can be issues of how tight you're slicing what it means to have a use. The example sort of I gave was traditional billboard versus electric billboard. Are those two different uses, or is a billboard the use? And you can regulate the billboard one way or another. It could be, we've allowed for, um, you know, 5 areas where you can have billboards, and someone says, yeah, but those really aren't real areas that anyone can really do anything with. So you've essentially excluded billboards by doing it that way, and they'd have to prove it. So I think it's really going to be very fact specific.
Um, One thing that had occurred to me as you're talking, are are municipalities possibly making themselves vulnerable to a rush to get, from some developer to get an application in because, they've announced that they're going to be entering into this process of, you know, looking at their amendment and I mean at their ordinance and saying, yeah, it was deficient, we want to improve it. And so knowing that it might still get approved now on the current language, would that be a risk for municipalities?
Well, it is, although what's the alternative? The alternative is you just leave the ordinance as it is, and they're going to come in under that ordinance anyway. So, um, it- you are, I mean, obviously, when you're dealing with land development, until the ordinance is fully enacted, it's someone can come in and grandfather, under a grandfather. I will say it's not, I mean, someone can get a sort of a quick and dirty plan in. It would have to still be administratively acceptable. But it's not something, I think it's difficult for someone to just do that overnight. So, but that's obviously a risk that whenever you're announcing a change, it's a risk that someone's going to try and get in under the wire. And that's kind of the way I use the
Hmm.
analogy of the race to the courthouse steps, where you're just trying to get in there before it goes into effect. That's a possibility.
Um, this isn't really a question, but a statement from Mike. A local ordinance regulating air emissions and probably noise as well is not subject to grandfathering concepts. A facility can be up and running and still be regulated through a new ordinance, like local clean air laws that he has drafted and used in PA and other states. Is that
Well, so there's two issues there. One is sort of the state law issue, and the other is nuisance and whether nuisance is something that could be grandfathered. And it's an interesting question. And generally, yeah, depending on the type of you're dealing with, whether it's noise, um, smell, things like that. Some of, that those are nuisances that can always, tend to be regulated. Even, that you can create a new law and then apply it. It's not a vested right the way land use determination might be. It's not necessarily a vested right. I always have to hedge because it's always on a spectrum. But it's the issue of noise comes up a lot when you're representing municipalities and someone says, oh, I've been, making this noise for a long time. And, the response is, well, you shouldn't be, and now you need to stop.
And Colby points out it seems a strategy is that landowners join together to form an LLC created by a data center developer, and then that LLC, who is now a huge collective landowner, files a curative amendment to have land rezoned to their liking. Have you seen that strategy?
So can you run that by me one more time? I'm sorry.
The landowners would join together to form an LLC created by a data center developer. So now they've got this gigantic LLC that's made up of, all the collection of landowners and
Right.
so they file a curative amendment to have land rezoned to their liking. Is that a strategy that you have seen played out?
I have not seen that. I'm trying to think. So they're essentially saying that they, as a property owner, they might want to get it changed what, but they still have to have something that they're claiming is invalid about the ordinance. Right? I'm assuming this is somebody who wants a type of industrial use or doesn't want a type of industrial use. I think if they don't want the industrial use just because it allows the industrial use, I don't know, unless you're saying that there's some other use that they're going to propose and say you haven't allowed for this, so I'm going to propose this.
I,
I don't know. I'm trying to think of a
yeah,
factual
Colby, maybe you
scenario where that
want
would
to take
apply.
yourself off mute and ask.
Yeah, I'll take myself on mute. Sure. Yeah, I guess what I was trying to convey, and maybe what I've seen, or maybe what I think I've seen, is landowners will all come together to form an LLC, and then that LLC will maybe submit a curative amendment as a landowner to now challenge that. Maybe each individual landowner could not do it on their own because they don't have that ability. But when they form together to make one gigantic LLC, then that LLC can make the claim that they own all 1,000 acres and then are submitting a curative amendment to, or a substantial validity challenge to get land zoned or a project through. I guess is what I was trying to ask or convey,
Yeah,
if
I
that
mean,
makes
so
sense.
are they interested in doing some sort of industrial use, or is it a strategy to stop an industrial use?
No,
That's
it's a strategy to get industrial. It's a strategy for a data center developer to get their project through, not in a
oh,
way to.
well, and so a lot of times what you'll see, I think I understand the question now. What you'll see is either, I mean, sure, people can band together. Look, a single property owner that owns enough property can do that, or um, a data center, even without owning the property. I mean, there's concepts of what they call equitable ownership, where you have an agreement of sale on in or leases in. Someone can make an application as the equitable owner, a tenant with the property owners, even multiple property owners' permissions. I don't even know that they have to band together if the company is going to be the applicant with the permission of the um, of the individual landowners.
Okay, thank you. Yeah, that answers the question.
Okay. Next question, and I think we have three in the chat. I think that'll probably have to do it because we're running up on at the hour shortly. And I know I wanted to give Maya an opportunity as a co-host to say a word or two before we close. So the next question is, our municipality doesn't yet have a data center ordinance in place. Therefore, we can't begin a municipal curative amendment until that happens. Doesn't that provide a developer an unfair advantage in submitting an application and getting it approved? Similar to my question, actually.
So I mean, if they just because they don't have a specific data center ordinance doesn't mean that their general industrial use ordinance may not apply. It may apply, right? Even if it doesn't say data centers, it may fall under the general definition of some sort of industrial use. So that's one thing. If for some reason they truly don't have an ordinance that covers this, they can say we think our ordinance is invalid because of that and start the process. The municipality can.
Okay. If a township already has a data center ordinance and developer puts in an application before the Second Amendment is voted on, but not has been advertised, does that mean the developer only needs to comply with the original ordinance? And again, I think that's
Yes,
similar to.
that's right. Yes, I think that's the answer to that.
And then finally, is spot zoning illegal in Pennsylvania? What is a good strategy to counter argue that it has been spot zoned after a small section has been rezoned through an overlay, such as in Columbia County, where neighbors are wanting their properties to be rezoned?
Spot zoning is a type of invalidity. It's a type of thing that can be brought through a validity challenge. And yeah, if it meets the definition of spot zoning, that is something that's illegal and can be set aside.
Well, thank you so much. We're going to turn now to Maya, who wanted to say a word before we ended today. But thank you again, Mark. Thank you so much. And thank you for everybody for the questions. These were really helpful questions, I think, too, for all of us to try to understand a complicated topic. So thank you for Mark for making it so clear, and thanks to everybody for your great questions. And with that, Maya.
Yeah, just really quick. So thank you so much, Mark. Super appreciate your jumping in so quickly into the fray. And I just wanted to share with everybody the reason why Green Amendments for the Generations and Better Path Coalition wanted to do this presentation is that there's been a lot of confusion, misinformation, mischaracterizations about what a curative amendment does and does not do, can and cannot do, will or will not do around the issue of data centers. And we really felt that this mischaracterization and or misunderstanding was giving people a false sense of opportunity and optimism that would come out of a curative amendment, and also resulting in them failing to recognize, how it could be used as a value-added tool. So that's why we wanted to do this. We just wanted to have Mark, who's a straight talker and a straight shooter, just come out and, just the facts, ma'am. So, we hope that you will be listening when you're out there in the world doing your work, whether it's around data centers or other land development issues. If you hear people talking about curative amendments, you think that they're misunderstanding what it is and what it does, please share with them this recording so that they can also become informed, and try to help set the record straight, because it's only by the accurate knowledge that we're going to be using this tool in the right way and not finding ourselves falling prey to actually creating an opportunity for the data center people who we know will take advantage of any opportunity that they can find. So thank you for joining. So appreciate you all for joining and the great questions. So appreciate Mark. So appreciate Karen. Better Path Coalition, Green Amendments for the Generations, and Delaware Riverkeeper Network are an honored member of the Better Path Coalition, and just really, really appreciate today's presentation.
And Maya, before we wrap, I wanted to make sure to let everybody know, because we are co-hosting, we're both going to be sharing the video. I'll be sending the link as soon as I have it processed today. I don't know if you can process it that fast, Maya. So where will people look to find it if they're looking to watch the video on your site? Will it be on Green Amendments? Do you go to your YouTube page?
Yeah, if you go to pagreenamendment.org on the resources page, we will have a link posted there, as well as other resources that we have about how Pennsylvania's Green Amendment can be used in the context of data centers, used effectively and again used wisely. And that's that's the Pennsylvania Green Amendment, right? There's also Green Amendments for the Generation. So greenamendment.org on the resources page. We will also, I'm sure, have it posted there. But pagreenamendment.org is probably going to be your best first place to look.
Okay,
Sorry. Thanks,
great.
Karen.
And again, Maya is going to be speaking about Article 1, Section 27, our Green Amendment in Pennsylvania, on Thursday evening at 7. So like I said at the top, look for that link for registering for that event in the email that I send as a follow-up. And again, if you want to be part of the conversation, we have all sorts of things going on the Pennsylvania Data Center Resistance page. So look for that link too if you want to join up and haven't already been part of that. Again, thank you all for joining. Thank you so much, Mark. We can't thank you enough for providing all this information on what has been a very confusing and misunderstood topic, frankly. So thank you. And
Thanks,
everyone, again, thanks for taking an hour out of your day to spend it with us. We hope that you'll take part in our future webinars that are going to be part of this series. If you have a topic in mind that you would like us to take on, let us know. You can just reply to the email that I send out after this with the recording link if you have an idea for something. But we do have a number of really good ones in mind for upcoming webinars. So we've got the plans in place for a lot of them, but we have, all sorts of opportunities to present others. So if you have a good topic in mind, let us know. And with that, I'll give you 2 minutes back, 1 minute back before 1 o'clock, and you have to jump to the next thing. So thank you, everyone. Take care and have a great rest of your day.
Thank you.